Hello and good evening and a very warm welcome to Mercantile Barristers construction industry webinars. Now, the primary subject of discussion this evening is how to avoid disputes and payment delays in construction. Now, before I kick off with the discussions, it's appropriate to discuss basic housekeeping. The format for the evening is that I'll be speaking to you for, I suspect, approximately half an hour. We have scheduled an hour for the webinar. I'll be speaking for about half an hour, and the latter half of the webinar will be taken up with questions and answers. So there is a degree of interactivity. Now, because of the information that we'll be sharing with you this evening, the webinar is being recorded. And by way of housekeeping, I'll be obliged if all could be muted in the first half whilst I'm delivering the content of the webinar. Now, it is only natural that whilst I'm speaking, things may come to mind or questions may come to mind which you would like to raise. Please feel free to type it in the chat. And if not in the chat, subsequently, when we go to Q&A sessions, you will obviously have opportunity to raise those issues. So in the first half, if you be kind enough to remain muted, and we will kick off. Now, the object of this series of webinars is, of course, to address issues that are uppermost in the minds of our clients in the industry. Now, clearly, there's quite a lot that we can go through, but time is always limited. So I'm going to adopt a slightly strategic approach to the issues that arise, and in the hope, of course, that individuals might pick up areas that are of particular interest to them and then raise those queries. So without further ado, if we may just kick off. By way of introduction, my name is Samuel Okoronkwo. You may all have already noticed that. I started my professional career as a quantity surveyor, and to those QSs attending this evening, hooray. I then progressed on to being a project manager and running some substantial construction schemes before defaulting into becoming a construction lawyer and a barrister. Now, I think my wife criticizes that progression in career as a sign of my hyperactivity and being too inquisitorial. And I'm sure some of you suffer from the same as I do. So that is the introduction. Now, basically contextualizing the issues that arise in the construction industry, I adopt the three perspectives. Now, as a QS, and those QSs attending this evening will recognize the impact that you are always seeing underestimated work packages, where contractors in competition may have just quoted a bit lower than it would actually cost them to get the work done. You see also a degree of claims consciousness. In other words, any and everything that happens on site is potentially tantamount to a claim. And of course, you will encounter certain clients who may inadequately budget for their schemes. Now, these are the key things to watch out for. From a project manager's perspective, you will be, from time to time, encountering inadequate planning and programming of construction projects. Now, over and above inadequate planning and programming, you also encounter inadequate resourcing, labor, plant, materials. That's what you need to build every project. Your main contractors have they provided adequately for that? Not always. Now, over and above those resources, information, drawings are a key part of delivering what we deliver in the construction industry. Now, there are a multitude of consultants, architects, engineers, a plethora of engineers, civil, structural, HVAC. Now, all of the information that is being provided, have they been coordinated? Lack of coordination of information causes untold difficulties on construction projects. And of course, because construction is a hybrid between science and art, you have to have contingencies. Whenever you budget your schemes, as you all well know, you make provision for contingencies. But are those contingencies adequately related to those issues in contract that couldn't possibly be adequately defined at the outset? Now, if you haven't made adequate provisions for those, now you're storing difficulties. You come back from the QSPM perspective, you come from a barrister's perspective. The cases that I deal with, one often encounters self-inflicted injury by the clients who come to you. They've done the damage. What you're doing is trying now to mitigate as much as possible. Now, what is also notorious in the industry is that more often than not, neither side to the dispute anticipated that there'll be a dispute. So you've entered this project, there are glaring issues that are looking at you where disputes may arise, but none of the parties have taken time to anticipate that and then do something about it. It is also very well known that when you actually get into formal dispute resolution, if you have started hiring solicitors and barristers, neither side actually wins. Unfortunately, there is this saying that the lawyers always win, but either the claimant or the defendant, neither side wins. I say this because even when you're successful, you will seek the recovery of your costs. Now, the costs, as you would appreciate, is at the discretion of the judge. The judge will never actually award you everything you've spent, unless, of course, you're recovering your costs on an indemnity basis. And indemnity cost recovery is not usually the norm. You recover your costs on a standard basis. In other words, you recover what the judge is content to allow you. It therefore means that you may only recover a proportion of that which you've spent. So you're not actually eventually winning. Now, of course, resolving every dispute that arises in construction is an expensive exercise. And just sit back and reflect upon it. If you have been involved in either a mediation, an adjudication, an arbitration, or litigation of any size, you would obviously have noticed the costs that are involved. That's whether you were involved as an employer, a contractor, or indeed a consultant in the middle. Now, so you sit back and ask yourself, what are the consequences of payment delays and disputes in the industry? The consequences are cash flow. We all know that cash flow is the lifeblood of construction projects. In fact, perhaps I should actually pause at this time. I know that a fair amount of the participants this evening might be inclined to take notes. But by all means, take those notes as much as you want to, but try also to not let me fly at a speed that you don't get it because you're writing notes. I say this because my clerk has reliably informed me that at the end of this webinar, he will be releasing the slides to all of the participants. So if you rather just sit back and listen in the knowledge that the things that you see on your screens will be coming your way subsequently, that's fantastic, because perhaps your attention will be more to what I say. But if you're the type that must make notes, by all means, feel free to do so. But having said that, I've touched upon the issue of consequences on cash flow, of payment disputes, and also you suffer loss of profit. You often see abandoned contracts, which of course is a substantial bedrock of disputes. There are invariably reputational costs to engaging in disputes. It may well be that relationships are wrecked, that rather than engaging on the next contract with the same team, you're saying, no, I don't ever want to work with these people again. Now, clearly, that leads on to the next point of future business opportunities disappear. You lose time also in the course of resolving construction disputes. And of course, litigation. I think one of the best advice that counsel can give you is to avoid litigation if you can. Now, it's not always possible. and in some cases it's inevitable, in which case you have to engage in it. The essence of what I'm saying is that where dispute, where litigation becomes inevitable, you ought really to find yourself or have put yourself in advance in a position where you've done everything possible so that you will succeed in it. So conceptually, therefore, now what you want to do is look at the delivery processes that you are involved in and try and stand them against the contractual provisions. Now, you must always, on each and every project, try and align your delivery processes with the contractual provisions. Because the contract always is the starting point of dispute resolution. So if there are contractual provisions and you have not adapted your delivery processes to meet them, invariably you will encounter a disagreement. Now, whether that disagreement eventually evolves into a dispute is another matter. Clearly, where common sense prevails, and common sense does not always prevail, as I'm sure you're well aware, disputes then follow. So it's just as well whenever you have a contract to engage in, ask yourself, what are those contractual provisions and how am I adapting my processes to suit it? Now, in an attempt to anchor the conceptual and strategic points that I'm making, I sought to look at some of the things coming across my desk to pick out a typical invitation to advice, which I hope, as we go through it, most of you can identify with aspects of it. Now, this is a letter that came to my clerk, addressed to me. It says, "Dear Samuel, we're looking to get some advice regarding a project that has consistently gone downhill, both financially and contractually, where we are undertaking the demolition and groundworks on a conversion project. As I am sure with most cases that you deal with, it is not completely black and white. Now, the project was started in the middle of last year under a modified JCT contract in which we had comments on and agreed changes via email, specifically relating to design responsibility that we refused to take on. Now, from the beginning of the project, there has been a continuous interchanging of management and financial persons and a lack of thought put into the pre-construction process. We were incredibly delayed on receiving the internal drainage design, which caused us to miss all of our key project dates set out at the beginning of the project. This was notified to them during the delay process. Now, since this time, there's been ongoing conversation about the lack of detail required to build a project. Furthermore, we have undertaken additional works following the reissued revised drawings and have gone unpaid as the client is disputing its credibility with flimsy clauses from the contract. At this time, those variations are worth around, I dare say, hundreds of thousands of pounds. We're now far past our initial agreed completion date, and we have no sight of finishing. There are continuous hold-ups with other subcontractors on the project, and their frustrations are the same as ours. So I'd be very interested in discussing this further with you. Now, this is how it often starts. Now, it's if you like, an extract from a request for advice. So I picked out from this basic request, which is a typical, as it often comes in, I picked out a dozen things that are worthy of further consideration. Now, the project has gone downhill financially and contractually. Just sit back and reflect on it. Those of you attending this evening, how many of you are actually involved in projects that are not progressing financially and contractually as it was intended at the outset? And this is progressive now, it's going downhill, and you're contemplating how to deal with it. Now, the second issue that I pick out from this is that there is ambiguity and uncertainty, which is clear. Now, the project commenced in the middle of last year with a modified JCT. So someone has taken time as I'm sure those of us attending this evening have encountered, to actually amend the standard JCT contract. There is now a substantial question mark on design responsibility. The point number 5 is the continuous interchange of management and financial personnel. Now, consultants are attending this evening as well as employers and contractors. Where you have personnel changes, you actually lose residual knowledge. And the question is the degree of continuity that might have been maintained, if at all. Now, number 6 is a critical one. It says that there's been a lack of thought in the pre-construction process. We often crack jokes in chambers, and we say the cases that are actually determined in court they're won in chambers because of the preparation you make in confronting the issues you have to deal with. Now, the same actually is applicable in construction contracts. If you have actually taken time in the pre-construction phase to think about the project and make adequate plans and prepare for it, the likelihood of you succeeding in delivering it is greater assured. But then how many of you have been racing as soon as planning consent is being given? We must get to site tomorrow. The contract's not even been drawn up. Here is a letter of intent, let's go. Now, the letter of intent, depending on how skillfully it may have been put together or otherwise, it may or may not have detailed the form of contract intended. Clearly, there is no contract sum. There is only an undertaking or a modicum of undertaking that the contractor's costs in getting to site early will be reimbursed. Now, the costs will be reimbursed. That's the agreement. But then what happens when we are rapidly with that speed? Because once construction starts, there is limited time, therefore, to do the preparation. So you find yourself going midway to the contract, or sometimes to the end, without the formal contract not being signed. You all, or a great deal of you, would have this experience. Now, the question then arises, what form of contract is to apply? Are we faced with the concept of quantum merit in trying to determine what the contractor will be paid? Now, to that extent, therefore, how is our employer's budget aligned to deal with this? But of course, the employer will say, you are my consultants, you are the architects, you're the project managers, you're the quantity surveyors, you're advising me on these things. I shouldn't be in this difficulty. Okay, so forethought and preparation, pre-construction stage, key. Number 7, delayed receipt of drawings and lack of construction details. Now, as we all know, there is a substantial gulf between concept design, design drawings, and actual working drawings. Now, where working drawings are lacking, you will find the contractor reeling off RFIs, request for information, on a minute-by-minute basis, day-by-day basis, week-by-week basis. It then is incumbent on the architect to receive the request for information in an organized, systemized manner so as to respond to it appropriately in order not to adversely impact the construction program, which of course is the key that determines the commencement of the contract and the completion of the contract. So there's delayed receipt of drawings and lack of construction details. They've, as consequently, now missed all project dates from the outset. Now, additional works following revised drawings being issued. Variations are now engaged. The bane of the life of QS in determining a final account, variations. Now, clients now refusing to pay for the variations, according to this client of mine, it is using flimsy contractual clauses. Now, the completion date, time is now at large, is in question. The client is under pressure because he's borrowed money for the development. And if he doesn't deliver by a particular date, his funders will have step-in rights to take over and potentially liquidate the company. And then there are, of course, item number 12, multiple contractor claims. So you can see here that there are, as I've as I've picked out a dozen key items from this single piece of advice request of things that you all will be familiar with. So if I now try to distill these dozen items, and in fact, all of the disputes that you encounter in construction projects, I tend to use a triangular illustration. You've got time, you've got cost, you've got quality. Money problem, cost. If it is overrunning, you have a dispute. Time is money because money is borrowed and funding has costs, and the costs are interest and fees. So if there are cost issues and there are time issues, you've got a dispute. Then you have quality issues. Now, this to a lesser extent, because if there are clear specifications, it ought to be that the specified standards and quality is met. But if, for example, you imagine circumstances where, because the contractor is running late, a lot of trades are piled up on top of each other because you have confined spaces within which they are working, you will find that naturally quality gets compromised. And if quality gets compromised, yet again, you have a basis for dispute brewing from that. So you avoid disputes and delays by controlling your internal delivery processes and your contractual expectations. Now, contractual expectations are usually fixed at the outset where there's been forethought in preparation. However, those also can change during the life of the contract. The question is, are you recognizing it? Are you alive to it? Are you therefore taking steps to ensure that if you have monthly project meetings, that you're recognizing those changes and trying to adapt your systems and your processes to match? Now, you pause here, and I said that the most valuable advice you can get from a lawyer is how to avoid litigation. Now, that is on the basis that you have taken time to anticipate the litigation or actually look at your contract to say, I see issues here, how can I avoid them? Is a stitch in time that saves 9. If you're in litigation, you've got 9 stitches that you need to put in to actually solve the problem. But before you get there, only 1 stitch can actually help you to navigate around it. So to assist in this regard, we did produce a checklist to help clients in the construction industry to avoid disputes. I then use these dozen items, which are listed there. I won't go through all of them because they would take time, but you will receive them in the slides that come through. It begins from your letter of intent, your contract sum agreement, and it runs all the way through your final accounting. This is born out of the experience of having to deal with these things on a day-to-day, year-to-year basis in trying to solve these problems. So they are worthy of attention and recognizing that here are the areas where the dispute's coming from and what can I do to actually deal with them. So for example, I'll give you an analogy. If you take time, there is always a duration for the contract. Okay, there is a start date and a finish date, but what most participants in the industry fail to recognize is that time is not really of the essence, unless time is made of the essence. Now, that is technical speak, which I'm sure a fair amount of you will be familiar with, but to the extent that you're not familiar with, the best illustration is that although it is said that is the 30th of June, 2021, that the contract will complete. The contract also recognizes that it may not complete on that date because, of course, the client may have introduced variations. If the client has not introduced variations, there may have been overrun on other aspects. But the service of a notice will then make time of the essence, but that is a specific item. But the key point I want to illustrate here is that if you look at the top of the slide, there is contractual provisions. At the bottom, you have 3 colors of completed project in green, orange, and red. If your contract starts at a particular time and forecast that it's completing after 52 weeks, if you completed on the 53rd week or on the 50th week, you will not have a dispute in that contract that is related to time. If instead of completing on 52 weeks, you're completing on 70 weeks, you're potentially in the orange. And there, there will be issues of liquidated and ascertained damages potentially being sought by the employer, or maybe a delay and disruption costs being sought by the contractor, Q dispute. Now, if you then are completing, as appears to be the case in most matters, instead of 52 weeks, is 100 weeks, you're definitely on the red side of this equation. You have double the contractual provisions. If the developer is still live in the scheme, he's now facing incredible issues with his funders, and his, if you like, elbow room to accommodate is far reduced, and that is where you have your difficulty. So the key issues that you are going to be looking at here is item number 4 on our checklist, which is your construction program agreement. Because when you start every project, you ought really to agree the construction program. If you are the employer, ask your contractor to give you a contract program which will be agreed. If you are the contractor, ensure that the contract program is agreed. If you are one of the consultants in the middle, if your client, the employer, is not picking up on this, insist on it, because guess what? Particularly the traditional forms of contracts, JCT, for example, is silent on the employer's ability to manage and drive the contract. It is the architect or the project manager or the employer's agent that has responsibility to run the contract. So if it goes wrong, it is on you that it lands. And I'll give you an example that comes to mind. I was consulted by a QS and project management firm that had decided in the course of a project that the contractor was so late and was not demonstrating any ability to be able to retrieve lost time, that they served a notice and determined the contract. As soon as the contract was determined, the contractor promptly served a notice of adjudication on the employer, claiming, I think on that, something of the order of 2.5 million. When the employer then reverted to his solicitors to deal with the notice that had come in, the solicitors concluded that the determination was defective, that the project manager QS has determined the contract wrongly. So the employer reversed and served a notice on his consultant saying, this determination is wrong. And as I have now been advised that it is wrong, whatever I suffer by paying the contractor is retrievable from you. You stand to indemnify me. Now, as it turned out on that occasion, I was consulted by the QS project manager to come and defend him in the prospective action that was coming from the employer. Having perused the papers and done a little bit of analysis, I reverted to them that they may be wiser in returning to their client and making a proposal. And the proposal is this: let us, the QS project manager, have total control of defending the contractor's notice of adjudication. If we lose, then you have a claim against us. If we succeed, then your claim against us, of course, falls away. As you are well aware, being professional consultants, the notice on them of professional negligence carried with it a requirement for their professional indemnity insurers to be notified of the imminence of a claim. And of course, that has consequent implication on the premium that they were going to face in the next round of renewal. Now, as that matter transpired eventually, they persuaded their client successfully, and I was retained to defend the adjudication. Suffice it to say that we were successful in defeating the contractor on that occasion, and as such, my clients did not then face the wrath of their client, and I'm pleased to say that they are both still working together today. So, the construction program agreement is a necessity, is vital. Now, it doesn't require a separate agreement outside of a contract. The contract obliges the contractor to proceed with the works duly and diligently in order to complete by a completion date. So your insistence that a construction program be provided is only reasonable and consistent with that contractual requirement. And once you have it, you want to ensure that you actually understand that program, that you can identify the critical path, i.e., from the site setup to the last activity that leads to practical completion. You want to identify the series of activities in which you have zero float. Because if you identify the critical path in which you have zero float, float, of course, being, if you like, the extra overtime that you have to do a piece of work. So, say, for example, if you've allowed 12 weeks for the external cladding. Now, if the external cladding happens in 10 weeks, you've obviously got 2 weeks float in that. But if it happens in 14 weeks, you've obviously overrun on that work package by 2 weeks. Now, you do your forward pass and your backward pass, i.e., you start from the beginning, get to the end to see where the zero float is, and you reverse that where you have net zero float on the line of activities, your critical path. You then want to watch the critical path like a hawk. Now, it doesn't matter that the construction items with a float are overrunning because you've got the time. You know, if your cladding, which I use as an example, has a float of 2 weeks, if it overruns by a week, it has no impact in your analysis of the completion date. But if your cladding has zero float and it overruns by 1 week, potentially you're adding a week to the end of your contract period. And it behoves you as the project manager, indeed the employer, and therefore also the contractor, to identify your critical path. And that's what you want to have your grip on in managing the construction project. And I say that you look upon the construction program, get an agreed one, and then watch it. Keep an eye on the specified date of completion. And what then happens in managing your critical path is to watch your construction information management. Now, construction information management is actually a very significant point. Now, I seem to recall an example many years back, whilst I was project managing what was then the Harlequin Shopping Centre in Watford, which has since been renamed a few times. Now, what struck me was that we were looking to deliver a 707,000 square feet worth of shopping retail, modern shopping retail shopping centre. Now, we were going at such a pace that we were casting floors practically on a bi-weekly basis. But in trying to get the concrete floors up, there was a necessity for all of the HVAC drawings to have been produced and the information coordinated, because you have air conditioning ducting, services pipes, crisscrossing floors. Now, in order for you to do that effectively, you actually need to identify the size of the hose required and put your polystyrene blocks to cast your concrete around to have your knockout panels. Now, in a section of the project, we proceeded and cast those floors without all of the drawings being coordinated. Now, the drawings arrived on site 2 weeks after the last floor had been cast. Now, of course, there were no holes for the HVAC pipes to go through, and none of the service pipes could therefore go through without you having to diamond cut the reinforced concrete slabs. Now, those of you that have been involved in diamond cutting need not be told how expensive it is, and also the amount of water that it generates. Now, because you're now cutting holes with diamond drilling on concrete floors, you have effectively put a full stop on all of the dry trades that were supposed to follow. So your delay is now being cumulative. And of course, to the extent that any dry lining would have been done in lower floors, they were promptly saturated. You can imagine the amount of disputes that's now been fomented as a result. So I give you that as an example with respect to time. If we look at cost, again, using the same analogy, if you were on a £2 million construction project and you're going to be final accounting at 2.05 million, it is safe to say that the likelihood of a dispute will be negligible, because the likelihood that the parties are likely over a brink agree the final account and then make progress. If, however, your 2 million has become 2.35 million, you're in the orange zone of my analysis. If your 2 million is approaching 3 million or 3.5 million, you're in the red zone. And what is then guaranteed to happen will be an almighty dispute that will take time. So what items do you consider here when you're exposed to disputes that are cost-driven? Did you start the project with a letter of intent rather with a proper contract? If you did, you probably need to go back to it. Now, do you have a contract sum agreement? It is fair to say that most contracts that are that are tendered have a proper contract sum agreed. Now, one thing is agreeing the contract sum. Another thing is to look into your contract sum analysis to identify how much of them are PC and provisional sum, prime cost and provisional sum. So prime cost, you've said, allow £200,000 for electrical installations. Now, what if when electrical installations are actually designed, they're coming out to 350,000? Is anyone taking reasonable account of that? So you look at your contract sum agreement, you revert to the signed contract documents, if any. Now, as a good cost manager on any project, as you go down the line, you should always be looking at the estimated cost to completion. Because, as I'm sure that the contractors in the house would appreciate, there are certain contracts in which you front load. And front loading enables the contractor to take the profit out of the project early enough in the day that if difficulties start coming down the road, the contractor is not overexposed. But if the contractor front loads, it potentially means that the employer is exposed. So a balanced appraisal as you approach your interim valuations on a monthly basis is always to have an eye to an estimated cost to complete. And it is in mutual interest that that is done. When I say mutual interest, the two primary parties to every construction project are the employer and the contractor. And of course, there are a plethora of specialist trade contractors down the line. Now, consultants are in the middle, but then consultants have the obligation to manage it for and on behalf of the employer. So we all have a collective interest in ensuring that our perspective on the estimated cost of completion remains reasonable. Okay, now there is the contract cash flow plan. That's what that should have said, contract cash flow plan. Now, if you have a contract cash flow plan that is reasonably related to the construction program as agreed, you will be able to identify where the cost expended is beginning to deviate from the performance actually being achieved on site. Early warning system, you see that because you're doing a sensible estimated cost to complete analysis, you should be able to bring them together and maintain that contract cash flow plan. You keep an eye on the specified date to completion. Now, item number 10 in this checklist is very significant. Now, you ought always to have a standard schedule for recording contract variation, not just recording the variation, but being able to get the cost and program impact of those variations on the project. So I'll give you an example, one that comes to mind on another dispute that I became involved in dealing with, the fallout. So this is a development in which is a high-value residential development for a city financier, which involved a swimming pool. And in the swimming pool, naturally, tiles have been specified. In the course of the construction, I think about 10% of the pool had been tiled when the financier's wife visited site and promptly pronounced that she hated the tiles in the pools and ordered the works to stop. The tiles were coming from Spain and they were on a 16-week delivery. The replacement tiles that she'd chosen had to be manufactured and delivered to order, and the construction project stops. Now, you stand there at the point there's been an instruction given to stop tiling. The pool contractors had to down tools, because I'm sure, as you appreciate, when they get to tiling the pools, they've already finished, they've broken the back of the construction. The question, therefore, is what is the program implication of that variation that's now been instructed? Has anyone recorded it? Has it been agreed? Now, that leads us to item 11, the variation, the project manager's approval of it. Because if you instruct a contractor to stop tiling because you don't like the tiles, now the contractor ought to come back to you and say, look, we need 2 weeks to place the order, 16 weeks to manufacture, we are facing an 18-week delay. Are you happy with that? If you're happy with that, the decision has to be made whether we are to remain on site and apply our resources to other parts of the project, or whether you are to vacate site and then return when the reordered tiles have been delivered. Now, unless that is captured appropriately, you will get to the point where the contractor is claiming 20 weeks extension of time as a result of what happened in the pool, and the employer is most reluctant to grant anything of the sort. And hey, presto, you're in a dispute resolution situation. And of course, final accounting, very important. What I say about final accounting is that try as much as possible by your penultimate interim valuation to have as clear a vision as you can to the final account. Now, final accounts that are left several months after the project has been completed are invariably and infinitely more difficult to resolve than those that are agreed reasonably quickly. Now, the nature of the beast is that, of course, it's not always easy to do so unless you've been on top of it. And this is where I say that there is a necessity to realign your own processes so that when you're looking at your penultimate interim valuation, you're doing a reasonable forecast of the final account. If you are the PQS on the project, you should be inviting the contractor's surveyor to either agree with you or give an indication that there is a level of, if you like, mutuality of understanding in that regard. So I'll come back again. I'll leave cost quickly, being conscious of the time, and look at quality. Again, using the same analogy, quality as specified, delivered, you're in the green box. Deviating from that which has been specified begins to put you in the orange box and then moves you into the red box. Now, letter of intent is engaged, signed contract documents are engaged, construction program are engaged. Now, you will know that those contract provisions will specify certain items or other alternatives as approved. Now, a contractor will always make a reasonable proposal to vary a specification because what they're providing will be of equal quality, but maybe of a lesser cost. That is all excellent, provided all parties are going on the same wavelength. You should also look at your complete list of construction drawings, construction information management, standard schedules again, and variations. Now, these are not entirely pigeonholed because you notice that one item in the checklist can have both cost time and quality impact. And I highlight in these discussions as they apply. So, come back to it. The primary reasons, therefore, for non-payments and reasons for disputes would include the ambiguity that exists in the contract. Now, if you sit back and look at it, a contract is supposed to be a clear and unambiguous mechanism for an effective distribution of risks between the employer and the contractor. Okay, clear and unambiguous. Now, but when you start then amending standard terms of contract, you introduce ambiguity. And when an ambiguity arises, a fair amount of you will be familiar with the concept of contra preferentum. Latin maxim. It simply means that if it is you that have taken the burden of redrafting the contract or amending it, any ambiguity that arises in that context will be read against you. So to those of you that venture to amend a contract, it is perfectly understandable that there are circumstances requiring standard terms to be amended, but do so with caution, because you potentially do so at your own peril in the event that it introduces ambiguity. Now, its ambiguity is, of course, failure simply to deliver. And sometimes people use contractual leverage, as you well appreciate. So these are the primary reasons for non-payment and reasons for disputes. So how do you avoid them? As I said before, if you align your processes always with the contract objectives, you will eliminate ambiguity, because where you see the ambiguity, you clarify it. And when you clarify it, you invite the agreement of the other party to the contract. And without a dispute, the other party to a contract is usually more obliging than otherwise in eliminating ambiguity. Because you've aligned, you also eliminate failure, and of course, you eliminate leverage. Now, so I say from experience that the cost of a dispute resolution is often 10 times the cost of preventing it. But experience tells me that the construction industry pay very little heed to avoiding disputes. They proceed in the misplaced expectation that a dispute never actually arises. But then you look at the technology and construction courts. In fact, the fact that we have a technology and construction court as a division of the High Court explains the fact that construction spews dispute like no man's business. And for those of you who are potentially of my vintage, who will recall Leighton's reports, which brought about what is today the process of adjudication, it is because of the sheer volume of disputes clogging the courts and the volume of contractors that were going out of business due to lack of payment and other construction disputes, that the industry resolved to introduce the process of adjudication. And for the first time, you cannot straightforwardly litigate a construction dispute without adjudicating it in the first instance, unless, of course, the parties have expressly agreed to the alternative. So if you consider that once you become involved in a dispute, you're actually spending 10 times that it might have cost you to avoid it, then perhaps it is a counsel of prudence to reflect that greater emphasis should be given to avoiding the dispute and incurring the costs. So I speak from the perspective of a barrister. I, of course, in the cases that I'm instructed and protect my clients in court, I can see the pitfalls. From a QS and project manager's perspective, I understand the realities of what is encountered in the course of construction projects. But what we tend to want to prefer to spend our time on is guiding our clients to anticipate where the problems will arise and then take steps to eliminate those problems. And if you can't eliminate them, ensure that you've so protected yourself that at the end of the day, you're not left holding the can, as it were. Okay, you're not carrying the can for the difficulty that arises. What you see there is a little pamphlet that will come with your slides on the analysis of what happens in that regard. So most people, and as I say, consult counsel when things have already gone wrong. It is far more prudent to obviously consult before the dispute erupts, because as I say, if you consult before, you use one stitch to save the 9 that you would use down the line in the process. Okay, so the checklist helps a great deal. By all means, try and deploy that checklist if it assists you in managing your processes. Now, on 1 or 2 occasions, people have looked at the checklist, it looks good, but they leave it on the shelf or in the drawer or in their drive where they save it. If you have the checklist, endeavor to implement it. Now, ask yourself, what is it that I do in the process? Which consultant am I, or contractor or employer? How can I deploy this checklist? If you can, by all means do, but if you require assistance in doing so, then have no hesitation to ask, because we can then assist and then guide you in that regard. So we have the dispute avoidance protocol that have key objectives to eliminate the ambiguity in the contracts, because every relationship in construction that you get into is a contractual one. Now, I say that, albeit that I'm presently advising on a matter where an employer has brought proceedings against my client, whose defense is that he was never the contractor on the scheme. But that's an entirely different matter for another day. But all your construction relationships are contractually based, as I'm sure you know. If you're a professional consultant, you have your terms, which your client has appointed you on. If you're a contractor, you have either one of the standard forms of contract or a bespoke one for that matter. It avoids confusion on variations and additional works, because if well managed, the confusion that arises as a result ought to be avoidable. You protect yourself from deviations in the program. Now, clearly, if you have the obligation to deliver, you may suffer a shortfall in resources, as the industry is presently suffering in terms of labor, plant, and material. Now, if you're suffering that, you should be able to adapt your programs to accommodate the shortage of resources. But if you're unable to do so, there are steps you can also take to serve appropriate notices to ensure that you are saved the consequences of liquidated and ascertained damages as a result. And it may well also be that deviations from programs are due to variations or other changes introduced by the employer, to which you're entitled to extensions of time, as well as potentially the losses and expenses arising therefrom. So the dispute avoidance protocol also helps you save significant legal costs. It reduces, if not eliminates, self-inflicted injuries. More often than not, when you receive your brief, you read it, and in fact, sometimes one's struggling to save one's professional client as well as one's lay client. And that is to say, if as counsel I've been instructed by a barrister, or by, in fact, the example I gave earlier of the professional consultant, it was clear to me when I saw the steps taken in determining the contract that there was culpability. However, there still existed sufficient grounds for the contract to have been determined. So it was more fruitful to save the professional client in that context by focusing on the contractor's failures, which enabled us to successfully defeat his claim of breach of contract as a repudiatory breach of contract, as it was in that case. The last item there is the elimination of leverage risk. Now, leverage risk, those contractors attending this seminar will be all too aware, where they have a significant amount of unpaid monies from the employer, and demands are being made of them, and they're also potentially leveraged with their bank, such that they're breaching their own borrowing covenants that they may well become susceptible to foreclosure by their bank as a result of non-payment on a particular project. In fact, I recently completed advising. In fact, the tail end of it is still subsisting. A conglomerate was wound up because of default on their borrowing, which arose specifically due to failure on a contract. And the issue there involved the liquidator as well that advised on it. And it was a clear case of leverage risk, where, if you like, the employer withheld monies and pushed the contractor into liquidation because they knew that the risk existed, and that was the way that they could save themselves a substantial amount of money from the final accounting. So therein concludes my straightforward delivery. I could go on all evening, but I'm mindful that we've all had a long and busy day,